Hey, thank you for joining us for our Patent Basic for Beginners webinar. This is the second webinar in our IP series that we'll be hosting throughout the next couple of months. Before we get started, I do want to touch on our Small Business and Inventor Hub that we just launched. This is a place that is designed to serve the unique needs of inventors, entrepreneurs, and small businesses with free resources and transparent pricing for tailored services. This is a great tool that we have developed for our clients and for inventors and entrepreneurs. So please go and utilize it. I think we have the link in the chat. So if you want to take a look at it and see what features it offers, and if you have any questions while you're looking at it, feel free to ask that at the end of the webinar. With us today is DBL Partner Rob Greenspoon. Rob, if you want to go ahead and introduce yourself.
Yeah, hi. So I am a partner. I manage the patent area at Dunlap Bennett and Ludwig, and I helped the team create the Small Business and Inventor Hub, which we're really excited about. So what I do in my daily practice, it's a mix of I help inventors acquire patents through the Patent and Trademark Office, and oftentimes I also help inventors in court when they run into infringement problems and they have to defend their invention in front of a judge or a jury. So I'm one of those. I think I'm unique in that I work at every level of the court system, up to the Supreme Court, the Court of Appeals, trial courts, what have you, as well as I help people write their patent applications. And then this is what convinces me that I may be unique, which is I'm also an inventor on a couple of patents.
Yes, you did mention that. Do you mind sharing with us a little bit about that?
Yeah, sure. So what you put on the screen in the screen share is the website for an existing company. It's called Bibboards. And what they do is they put out basically the invention that I patented and that I invented, which is a replacement for the safety pin for racing numbers. So if you've ever run in a 5K race or a marathon and you've been fumbling around in the starting chute with your safety pin and you stab yourself, well, this is the thing you need. The great thing about Bibboards is that it's really a great mode of self-expression because there's a way on the website where you can upload your own custom images, or you can choose from stock images, and they'll ship to you pretty quickly. I used to have more involvement in the company, but I'm really kind of faded into the background. There's a really great businessman named Brian Goodell who runs the company on a day-to-day basis.
That's awesome. Yeah. I have myself have fallen into that trap of stabbing myself with the safety pins, trying to get those on and getting them on for tryouts and whatnot for various sports.
Yeah,
This is
that's right.
great.
And I know we'll get into the patent document and the patent process, but I think let's start with my experience as an inventor, because I think I had the same experience that almost every inventor has, which is I wanted a solution to a problem. And I was in the starting chute of a 10K race or the marathon or whatever it was, and I myself was having trouble putting on my bib, and I saw last minute runners coming into the chute and they were trying to fumble with the safety pins. So my first thought was, well, I want to go home and I want to buy that safety pin replacement. So I went on Amazon or whatever, and I looked on the web. I didn't find a solution, so I just had to invent one.
No, absolutely. Now I pulled up here what I believe is the patent application, if you want to walk it through it with us a little bit.
Sure. So what you see there, and we're going to use this as, I think, an example of the anatomy of a patent. And are we able to scroll through it to
Yeah,
the different pages?
absolutely.
Okay, great. So let's go back to the first page.
Okay.
The first page will have the title. And by the way, what is a patent? A patent is, in one sense, it's just a piece of paper. These days, you don't get the paper, you have to print it yourself. But it's an electronic document oftentimes when it's issued by the USPTO. And let's go to the very end of the patent, because that's actually more important. At the very end, you'll see,
This it?
let's go one page earlier. You'll see what are called the claims. And the claims are where the rubber meets the road in a patent. The claim is like a deed to real property, in the sense that there are words. You see I claim on the bottom, the third column of 4. on the bottom. I
Right
claim, and
here.
then there's paragraph starts with one. That would be called claim one. And claim one will be sort of a word picture of the perimeter of the property rights represented by the patent grant. So I like to tell clients to think of it like a checklist. If
Mm,
you put a little empty box next to every subparagraph, and then a product is covered by that claim if you can put a check mark next to every checkbox that the word description is there in the thing that you're looking at.
that's an easy way to think about it. I wouldn't have thought about it that way if a simple checkbox.
Right, right. And in fact, and this is off topic maybe, but in infringement controversies, the question always is there infringement or is there not? And you get into all kinds of philosophical questions about what words mean, because the typical setup of an infringement case is that a patent owner will say, I can check every empty box, so I have the full list of check marks for claim one, and then the accused infringer will come back and say, not so fast, look at the next to last checkbox. We don't have the widget in our system, whatever. That's the typical anatomy of an infringement controversy.
Wow, that's interesting. It's very technical in that aspect. So I know you had mentioned what a patent is essentially, but could you kind of tell us the different types of patents that there are?
Sure. So in its wisdom, the U.S. government, under its mandate under the Constitution, actually, has set up basically three different types of patents. One of which I will confess I know almost nothing about, which is the plant patents. So we're not even going to talk about that. But there are other people who specialize in that. Um, but if we're talking about other types of patent, the other two types, they are utility patents and design patents. And a utility patent is like what we just saw on the screen. It'll be a multi-page document typically. There are one-page patents in the world. They're unicorns, but it's typically a multi-page document with the claims at the end and a written description in the middle. There are some drawings near the beginning. And
Mhm.
then you also saw that first page is what we call a bibliographical page. Most of that is actually written by the government, believe it or not. But the rest of it has to be written by either the inventor acting as his own attorney, or a patent attorney or agent will help the inventor by co-authoring, if you will, the bulk of the patent document.
Okay.
So that's a utility patent. And what a utility patent does is it protects a machine, an apparatus, a method, you know, so article of manufacture, sort of the typical things you associate with something that should be patented. On the other hand, a design patent, and I don't think we have a picture of that yet, but a design patent is a little bit different. It's almost entirely a set of drawings, and it's really more intended to protect the ornamental design associated with an article. So to my mind, the quintessential design patent is, there's a new design for silverware. you
Mhm.
know, the fork and the knife have already been invented, so nobody's going to get a utility patent on that. But you can definitely make new designs, new ornamental configurations of a fork or a knife or a spoon. And so silverware design patents are very common,
Okay.
and the list can go on and on.
That's a great example of silverware, like fork and knife, like the variations and stuff like that.
Yeah, where it gets exciting and maybe even a little confusing is that these all can overlap. So think about the Apple iPhone. For
Mhm.
sure, Apple has thousands of utility patents that cover whatever they've done in the iPhone, but it's not really as common knowledge that Apple has a whole basket full of design patents to cover
Yeah,
the design of the iPhone, and they had a successful infringement case on the design aspect against Samsung about 10 years ago. And the design was really about the rounded corners on a rectangle, if you
I think I
believe
heard
that.
about that.
Right, right.
Yeah, no. It's always something between Samsung and Apple.
Hmm. Yeah, they hate each other.
Yeah. So I know in the IP world we hear trademarks, copyrights, patents. Now, how does patents differ from trademarks and copyrights?
Yeah, so a patent is an exclusive right for a limited term of years, whether or not you're practicing something.
Okay.
For example, we put up my Bibboards patent.
Mm.
Let's say there never was a company called Bibboards that owned that patent, which it does right now. So let's say I just had what we call a paper patent or a shelf patent. I am still allowed, if I own that, I'm still allowed to enforce that patent against infringers or get licensing revenue from it. I can license it out, or I can use it as sort of a piece of property that I own to use as collateral for financing for a company, for a new company. You know, that you can, that we haven't touched on that yet, but a patent is personal property. So
Mm.
if it has value and if you can convince someone else of the value, then you can use it to secure financing.
That's awesome. I actually never knew
Yeah,
that.
yeah. So, but back to the difference between patents and trademarks and copyrights. So, a patent will give you the. This is the theory of it. The practice is more gray. The theory of it is that a patent gives you the exclusive right for in that claimed invention, so that you are allowed to go to court to get somebody to stop to have the court stop somebody from practicing your invention. So it's a negative right. It's not a positive right. It's often this gets into theory of it all. But you can use a patent to go to court to get an injunction against somebody who is infringing, whether or not you're in that particular business, as long as you own that patent. It's different from a trademark. A trademark protects not an invention or the implementation of an idea. A trademark protects your goodwill and reputation that you've earned as a business in the marketplace.
Mm.
So to have a particular trademark, let's say the McDonald's trademark, for example,
Yeah,
we would call that a word mark for restaurant services in the fast food realm. So the McDonald's trademark protects McDonald's from folks who would free ride or try to capitalize or bandwagon onto their reputation by stealing their name.
that's a great example. McDonald's is known everywhere, well, with all the
Uh,
mix and everything.
yeah, yeah. And there are a zillion examples we could use. Yeah.
No, definitely.
Yeah, trademarks tend to be easier to understand or more people are more aware of what they're about, I think, than patents usually. Now, fast forward to copyright. Copyright is here's a book. This is a work of authorship, right? So copyright protects the expression of ideas. I'm not getting this exactly right, I'm sure, but copyright protects the author of a book, for example, from someone who might copy the book. So that protects against outright copying by someone who has a work of someone who has a work of authorship.
So kind of keeping people accountable for producing their own thoughts for
Right.
copyright.
You could say that for sure. And copyright goes to protecting not just written works, but also works of sculpture, paintings, like the artwork behind me would be copyrighted.
That's
So
awesome.
if you are the author of these images and you own the copyright in these images, then you can go to court under copyright to protect against somebody stealing those images.
Oh, wow. So definitely don't copy other people's stuff.
Don't do it.
Don't do it.
It's too easy on the web, control C or whatever on an image.
Yeah.
Don't do it. Don't do it.
No, definitely.
Make your own work of authorship.
Or give the credit, right?
Well, giving the credit isn't enough often.
Oh,
That doesn't immunize you from a claim of copyright infringement.
well, good to know.
Off
Won't
topic,
do it.
but
Yeah,
back
off
to pat
topic, but
back to
good
patents.
good to know. So back to patents. What is the criteria that an invention must have to meet to be patentable?
Uh, quite a number, and no one's going to be quizzed on this, but I'll just rattle them off. First of all, an invention has to be patent eligible. This is an up and coming requirement in the patent law. For example, a dance move that's you can't have a patented dance move. That's choreography. You might be able to copyright the choreography, but you can't have you know, a patented method of training a horse. I think that's a famous one that Justice Scalia came up with. Um, it has to be a machine, article, method something that's traditionally an invention. So patent eligibility is the first requirement, and this often comes up in software cases. Oftentimes you need a professional to sort of tease out what's patentable and what's not when you have a piece of software. Beyond that, the invention needs to be novel, meaning the sort of patent claim that you're thinking of writing to go at the end of the patent has to be one where no one else has put those, let's say, 5, 6, 7, 8, 9 items together before in that particular combination. So that's novelty means it's new. That's all there is to it. Even if a little thing is different from what came before, it's still considered novel and new. But you're not to the finish line yet. Even if you're new, you still have to pass another hurdle, which is called the non-obviousness requirement. They used to call that inventive step, or sometimes they used to call it flash of genius. Those were kind of abrogated in favor of something a little bit more bureaucratic sounding. Now your claimed invention has to be non-obvious. And then finally, beyond that, the actual patent application that you write has some formal requirements, which is why it's often a good idea to have a patent attorney or agent help you through that process.
No, definitely. Now, what are the typical steps, since we talked about, you mentioned the patent application, what are the typical steps involved with that?
Well, the first step is invention. So picture me in the starting chutes of the Chicago Marathon. You see a problem and you come up with a solution. And in my case, I came up with a solution of a two-piece plastic fastener where they snap together, the pieces snap together, and that way you can hold your racing number on. Okay, so that was my flash of genius, putting, snapping two pieces of plastic together. We can debate that. But then once you've formulated a concrete idea of what your invention is, how you solve the problem, you can't just have the idea of eliminating safety pins. You have to have an implementation of an idea. And in my case, it was a two-piece plastic fastener that snaps together. Once you have that more concrete notion and you're ready for patenting, then it's always the best practice to sort of write down, even in your own words, 3 sentences. It could be one sentence, could be 3 sentences. It could be 100 pages, depending on what you're talking about. But you want to write down what we call an invention disclosure, and that's going to be immensely helpful for the next phase, which is you have to begin the true patenting process either by yourself, which can be done. There are some very successful inventors who've been what we call pro se, but more often you want to hire a professional. And so oftentimes you will convey that document, the 1 to 3 sentences or the 100-page invention disclosure, what have you. You convey that document to your hired professional, and then you get the ball rolling on a discussion of the patenting process. At that point, your patenting professional will probably interview you, get many more details about your idea. You'll probably go through what we call a prior art search in order to really, really hone in on, okay, what can we patent in this overall environment? And then after the study of the prior art search, different patent professionals do it differently. Some people like to start by writing the patent claims that they would file in the application, the very final part of the patent first. I do that sometimes. More often, I write out the sort of a background of the invention section of the patent, and then I write out a detailed description of the patent. And I also work with an illustrator. That's usually a third-party vendor who specializes in patent illustrations, which have their own sort of rules and requirements. So with the illustrator's drawings and the inventor's invention disclosure, you put together the formal patent application, and then you put that on file.
So it really takes a village.
It can involve a lot of people. Oftentimes the patent searchers are vendors as well. Sometimes it's the attorney or agent himself or herself. Sometimes I experience this a lot with one of my clients is MIT, and we work with professors and grad students, and oftentimes they have a very, very solid idea of what's going on in their field. So, judgment call. Sometimes you don't need to do a patent search if you're dealing with folks who are extremely aware of
Mhm.
the state of the art in their field, and then they will supply you with the latest journal articles or what have you. So it does take a village. Sometimes it's vendors, sometimes it's the inventor, sometimes the patent professional himself or herself will do a lot of these jobs.
Wow, that's a long process, I'm sure.
It can be. Please don't ever retain us with only 1 week's notice. That is uncomfortable.
As you heard, it takes a village. So, in order to have inventorship, who is able to have inventorship on a patent?
Yeah, that's an interesting question. There's a legal standard that wraps around that. And quite frankly, it's one of the most difficult to apply legal standards in the entire patent law. Because I'm gonna just rattle it off, and you think about what this means. Um, an inventor, a proper inventor or collection of people can be inventors. An inventor or joint inventor is the person or persons who have contributed to the conception of the claimed invention. Contributed to the conception.
Wow.
So the sort of bookends for this concept I like to put on it is imagine you have, a team of half a dozen people in a car company or whatever, and they're
Mhm.
sitting around a conference room table and they're coming up with a new idea, but there's one little hiccup. There's some detail about a sprocket that they just don't know what's existing in the marketplace right now when it comes to these particular sprockets.
Mhm.
So they say, "Hey, call Joe in." So someone picks up the phone. They say, "Hey, Joe, come into the conference room and speak to this group of 6 people." So Joe walks into the conference room, speaks to the group of 6 people, explains the state of the art in sprockets, and then
Mhm.
walks out. Right?
Mhm.
Follow so far. Is
Yeah.
Joe an inventor for whatever they come up with? Probably not, because
No.
all Joe has done, he hasn't really collaborated on the solution. All he's done is he's walked into a room and he's lectured the people in the room on the state of the art, the existing or pre-existing technology. And then he walks out, and it's the other 6 people who design the new and improved oblong or square
Mhm.
sprocket or whatever they're going to do.
Essentially, Joe is just a research tool.
Yes, right, right. But when it comes to groups, the law is very lenient, and you don't tend to have a lot of documentation. Like if you want those particular 6 people to be inventors on the patent, there's not really going to be a lot of second guessing about whether those were the right 6 people, as long as they were in the room collaborating when the idea was devised.
Okay. So all good things to know when coming up with a patent and figuring out who you're going to put on as an inventor.
Right, right.
Yeah. So I know you mentioned the term patent search. How does somebody go about conducting one to ensure their invention's unique?
Well, the first thing you might want to do, especially if you've got a consumer product idea, the first thing you might want to do is what I did. See if you can buy it. See if you can find the thing you came up with by going on to the usual suspects, Amazon, eBay. Nowadays you have Temu and Shine, whatever. Just see if you can find it. If you can't, that's a good start, but that you're not done. If you can't find the exact thing, then if you're doing it by yourself, this is going to be pretty tough. There's a pretty steep learning curve for using this particular tool. It's called Patent Public Search. Uh, about 2 years ago, the Patent Office shifted from one platform to another, and you can search prior existing U.S. patents and patent application publications on what they call Patent Public Search. So if you Google that, it'll come up. The problem is the Boolean search terms, the framework for how you create the search is extremely complicated, involving uh, dots and periods and field codes that you wouldn't really expect. But if you can learn that process, then you can get a lot done even as a pro se person just by yourself without hiring anybody. You could find a lot of relevant prior art, so you can get a better idea of where your point of novelty might be, what you might have developed that's different from what everyone else did.
Interesting. So most time you'd suggest hiring somebody to help you with that if you can't figure out how to work that platform.
To me, it's always best to hire a professional if you're going to do a patent search because that's what they do all day, every day. And what the deliverable that a professional will give you will tend to be like a vendor who specifically does patent searches.
Yes.
The deliverable will tend to be a report, which will include, attachments or exhibits of the various pieces of prior art that they found. They tend to be very careful in those reports not to draw conclusions about ultimate patentability. That's
Yeah,
going to be the job of the attorney or agent who reviews the report and works with the inventor to figure those things out. But the vendors tend to be very good, and they will give you a good result.
that's good. So everyone heard. Most likely, it's better to hire a professional so you don't come across anything.
Right. That's absolutely right. And then your final backstop, by the way, is the patenting process itself. You'll have a patent examiner, and the patent examiner, that person's job is to search the prior art. So even if for whatever reason you've foregone, you've decided not to do a patent search or a prior art search, the patent examiner will do that. So you will get a, um, a sort of portrait of what the state of the art is from the examiner during the patenting process.
Oh, that's good. So, what are some of the common reasons for patents to become rejected at patent applications?
Yeah, the most common reason is prior art. Uh, I think the statistic is that 93% of first official actions by an examiner are rejections in utility applications. And this is true for individual inventors, small businesses, right up to Microsoft, Apple. They face the same hurdles. But the rejection is usually an opportunity to sort of figure out, okay, well, maybe the examiner did find a good piece of prior art. Let's draft some narrowing amendments to the patent
Hmm.
claims this is our jargon, to overcome that prior art. So the process of patent examination tends to be a rejection, and then let's call it a negotiation process between the inventor and the examiner, where either you point out just obvious errors in the perception that the examiner has on what the prior art is,
Hmm.
or you will amend the claims to overcome the prior art to sort of add limitations to make sure that you're not that even over the prior art that's cited against you, you are still novel and non-obvious.
Okay, so there's some steps and things that you can do to overcome the rejection.
Right. And they have these funny terms. There's the non-final office action or non-final rejection, which sounds great. It's non-final. You basically only get two shots in
Okay.
any single examined application. You get two tries to convince the examiner. The first try is when you first file and you don't even know who the examiner is. And then the second try is when if assuming they reject your patent claims. The second try is when you attempt to argue or amend around a rejection. And then what happens after that? If you cannot succeed in that round, that second round, um, if you don't succeed, then they issue what's called a final rejection. But I always tell all my clients that's a misnomer. I mean, final is never final at the patent office. There's always either a procedural way. Now it costs money, of course, unfortunately, but there's always a procedural way to have another chance to keep your patenting prospects alive. It might require filing a brand new patent application that's
Mhm.
sort of daisy chained back to your first one. That's when it can cost a lot of money. But the so-called final rejection often isn't final because you can file a new application and start that process over again with now using the things you've learned through the first
Mhm.
examination process. And even if you don't do that, there are chances to negotiate with the patent examiner after a final rejection. And maybe in this, I've succeeded in this many times, but I've also not succeeded in it many times, candidly. So you can have an after final negotiation process with the examiner and see what you can do there.
So is that the sole role of the patent examiner to do the search and determine whether or not the patent is accepted or rejected?
That's a good description. I look at them. I mean, they're public servants.
Mhm.
They tend to be you could call them low-level government bureaucrats, but they tend to be very interested in their jobs and very enthusiastic, and they want to do right by all the inventors
Mhm.
who come before them. But they have an important mission, which is not just to grant patents that are patentable, but they have a job where they have to make sure that claims that are not patentable should not get patented. So in other words, you don't want to have this what they call the sword of Damocles. We shouldn't go there, but they don't want to have an improper patent monopoly coming out of the patent office. So you've
Okay.
got this cadre of people, I think it's 5,000 examiners or something like that,
Wow.
who have the sole responsibility to make sure that, let's say, a completely anticipated non-novel invention never gets patented, because that would create havoc in the marketplace.
And then how could I interact with them during the process? Is it just by going back and forth with what they rejected originally? Or how does
Uh,
that work?
it's pretty formalistic. I mean, there are specific opportunities to communicate with the patent examiner at times when it's important to communicate with them. And outside of these opportunities, it just doesn't help you to try to communicate with the patent examiner. So, in other words, let's say you've just filed your application, but you've received no official action, but you see your assigned examiner Smith.
Hmm.
2 years have passed and you want examiner Smith to hurry up. It doesn't do you any good to pick up the phone and call examiner Smith and yell at him for being so slow. That just doesn't work. However, once examiner Smith issues, let's say, a non-final office action, maybe allowed some claims, rejected some claims, that is the time when you can have not just a written response, but you can have what's called an examiner interview.
Okay.
And either the professional attorney or agent by themselves, or the professional with the inventor on the line can have a phone call. You can even have an in-person meeting, although those are increasingly rare. I've done it before. You can have an in-person meeting with a patent examiner, which, in Alexandria, Virginia. But most typically, these are phone calls, conference calls, and they'll give you a half hour of your time. I'm about to do one tomorrow morning at 8 a.m.
Oh, good luck.
with an inventor located in Italy. So,
Ooh, that's
yeah,
cool.
right, right.
So I know you mentioned if it's taking a long period of time, how long does the typical patent take to be approved?
Uh, I'm slow to answer because there's a way to make it faster. I'll start with that. At the very outset, you can pay a very large government fee to get into what's called Track One, which is the super speedy accelerated program. The super speedy accelerated program will get you, I think it's a guaranteed first office action within 6 months. But here's the catch. Uh, the government fee is about 5x
Wow.
what it is for non-track one. So it's not really an option for most people, and you only use it if you have a really good reason. That's my experience. So let's assume you're not track one.
Hmm.
Um, the fastest I've myself experienced getting an issued patent after the application date is 13 months. That
Okay.
was that was lightning speed.
Wow.
Uh, and that included a rejection where we had to file a response and amend the claims and so on. But we got that issued after 13 months without any kind of special accelerated examination. Um, on the flip side, I have some cases where after 4 years, I'm still waiting for a first office action.
Wow. So it definitely takes patience.
It can. I think you really have to look at median statistics to get a
Okay.
sense of it. And I think the median statistics, where half are faster, half are slower, is something like 2 years to your
Okay.
first office action, maybe 18 months.
Well, that's a good time frame to keep in mind if you're gonna get something patent to not be too eager. It's gonna take some time.
Yeah, and our terrific staff, I mean, they field phone calls all the time from inventors who are wondering, I paid all that money, where's my patent? And we just have to patiently explain to them, it's the government. It just takes time.
Well, when you think about it, I mean, there's 5,000 of them, but people are probably submitting patent applications like by the hundreds, and they have to really do thorough investigation.
Right. And the examiners themselves, they have what I guess you'd call a docket. I mean,
Mhm.
they have an ever-growing docket of cases, and so they have to go into those cases in a certain sequence.
Yeah.
So you can certainly understand why it can take a little bit of time.
No, absolutely. And you've been mentioning the term prior art. Is this the same concept of doing the previous search and stuff like that? And like of what we were talking about earlier, of like searching for prior things? Can you talk about the
Right.
significance of that?
Right. So prior art is there's a legal definition, but here's the sort of layperson's understanding of it, which I think communicates it very well. It's just a storehouse of human knowledge that predated your invention. So whatever anyone has thought of, written about, built, that's in the field of your invention or reasonably close to it, that's the prior art. Now, the legal definition centers on the format that you find it in. So the prior art can be in the format of a prior issued patent or prior published patent application, or it can be a foreign patent. It could be written in Polish or Hungarian or Chinese.
Mhm.
Even if it's not in English, it's still considered prior art for United States patenting purposes.
Wow.
Um, and then beyond publications, and that can include journal articles, that can include blogs on the web.
Wow.
Beyond that, you have public knowledge, things that are publicly known, publicly disclosed, even if they're not written down. So imagine a lecture at a trade show that can qualify as prior art if there are no obligations of confidentiality. And then you get into sort of the esoteric edge cases, which don't come up too often, but sometimes you can convince an examiner that they found something that they thought was prior art, but really isn't.
Mm.
Um, so I can think of a design patent issue that came up not too long ago where the examiner found a Facebook post, and it was a dated Facebook post. I mean, it qualified as a publication, so it
Yeah.
qualified as threshold prior art. But what we were able to convince the examiner about was that it was a design application. And what was important there was you've got, the six sides of a cube in
Hmm.
terms of the views of the ornament that we're talking about, the front, the back, the side, the top, the bottom.
Hmm.
And this particular image in this one Facebook post was only obviously from one direction. So we were able to convince the
Wow.
examiner that there were details that wouldn't be viewable. So therefore, you should disregard this as prior art because it doesn't show all the views for design patenting purposes. Um, but other esoteric things are, if your grandmother told bedtime stories to your mother, and the bedtime stories happen to include a full concrete disclosure of, let's say, bib boards. That wasn't a public disclosure. So even if you get five people issuing sworn statements that grandmother told mother about the bib board's invention, that wouldn't qualify as prior art because that's not public knowledge. That's not a written work.
Wow. So it's got to be publicly. It's not through told stories or somebody said this or somebody I know had this idea or
I wish I could say categorically, yes, it's got to be public, but there are even exceptions there. So
there's always
sometimes
exceptions.
there are always exceptions. So what raised my hackles when you said it has to be public is there are cases where the courts will treat something as prior art if it
Mm.
was sold. Like if it's in, let's say, a
Ah,
black box where you can't take the box apart, nobody knows what's inside the black box. But if that item is sold, the courts will usually treat that as publicly disclosed. They will treat what's inside the black box as prior art.
so really it's just important to do your research and have a attorney on hand to help you navigate those prior art situations.
Yeah, attorney or patent agent.
Yes.
I've used that term, so let me explain what that is. So a patent attorney is somebody with a law degree who also has passed what is colloquially called the patent bar exam. So what we call it is the registration to practice. So if you're a barred attorney, so I'm a member of the State Bar of Illinois, for example, and I passed the patent bar, now I'm registered to practice in the Patent and Trademark Office, and I call myself a patent attorney. But there is a whole universe of folks out there who don't have a law degree, but they are still able to sit for the patent bar. And if they pass the patent bar and they don't have a law degree, they call themselves a patent agent. But it really happens that, patent agents can't advise you on legal matters outside of patent prosecution, but within the bubble of patent prosecution, they're often just as good and sometimes better than patent attorneys.
Yes, they are definitely really good at what they do as well.
Yep.
Now, I know you mentioned you're actually going to be meeting with a client who's in Italy tomorrow. So how does that work? How can one protect their patent rights internationally?
Yeah, very good question. Let me give you the generic answer rather than that person's or that company's answer.
Yeah.
The generic answer, if you're a United States resident and you want to get patents internationally, you can do it either directly or indirectly. You would do it directly by just hiring, a Mexican patent attorney or a Canadian patent attorney, or these are all national laws. So you at the end of the process, you have to get a national professional who is in that territory, in that jurisdiction. But what's much more common is there's a particular treaty called the Patent Cooperation Treaty, which allows you to file one application that you may get to spread it to many different countries, up to 160 countries, I believe, at, of course, exponentially growing expense if you pick too many. But you can file a patent cooperation treaty application, and then you have a period of time within which you choose what jurisdictions you want to bring that application into. So, for example, if I have John Smith as my client, a typical prosecution strategy that includes global rights will be on the same day we file the non-provisional United States utility application
Mhm.
and a patent cooperation treaty application. So two different things, two different applications, two different fees. We file them both at the same time. The PCT application within 30 months, so there's a pretty good window of time, we decide, well, we want to try out for patent protection in China, the UK, and Uzbekistan. You can do that through the PCT. What you do is you now hire professionals in China, the UK, and Uzbekistan, and they will take it from there. Once you've made those choices, they'll be able to utilize that PCT filing that you as a United States professional have filed, and bring that into their own jurisdiction to carry that ball forward.
That's awesome. So really it's pretty not, I wouldn't say easy, but resourceful to have that if you were to have the patent internationally, where you're able to have that and then you're able to hire certain people.
Yeah, and just a piece of trivia, I have yet to hear of anyone, even the largest drug companies in the world, ever filing a patent in every jurisdiction. It just doesn't happen. The expense is just too high. We're talking about 160 nations.
Yeah, wow. That's crazy. So jumping tracks, and I've kind of gotten a lot of my questions answered. What are some famous patent disputes and lessons that can be learned from them? So we can give some examples to our audience members.
Yeah, I like to go back to the Wright brothers to just
Yeah.
to if I'm storytelling, because the hero of that story is actually the patent attorney.
Interesting.
Yeah, that's true. So the Wright brothers, of course, invented the first heavier than air controlled flight. Um, and what they disclosed for their wings were bendable wings. They didn't.
Mhm.
They might have disclosed ailerons in some fashion or another, but it's a little unclear to me. But they're definitely their main embodiment, the thing that they actually flew at Kitty Hawk, was bendable wings. That's how they controlled. I think it was the lift of their aircraft. The patent attorney came around and realized, well, there are other ways to do this. We don't want to just claim bendable wings. We want to claim all ways to get you the most maximum rights possible. So with the patent attorney who worked with the Wright brothers,
Mhm.
drafted claims that were broad enough to cover aileron technology. I'm probably mispronouncing that word. Aileron technology, which those are the little subparts of the back of the wing that go up and
Yeah.
down. You can see it when you're flying. And of course, that's where technology eventually went. So why is the patent attorney the hero of the story? It's because the future non-infringement arguments by like the Curtiss Aircraft Company centered on, well, we don't do bendable wings, we do ailerons. So they tried to say you can't put the check in the checkbox
Yeah.
because we do it differently. And they said, you're wrong. We can put the check in the checkbox because we are agnostic about whether you use ailerons or bendable wings.
That
The way
is
we wrote the
awesome.
patent claim. Yeah.
That's so neat. I love that. I love hearing different things and how history can affect everything, you know?
Yeah.
How it's relatable to what we're talking about today and how you have to be able to check the checkbox, but also kind of amend what you originally submitted.
Yep.
And then I know we have a couple of minutes left in today's webinar, so I want to open the floor to our audience members. If you have any questions, please go ahead and put them in the chat for us. Rob will be able to answer any questions you guys have. And then if not, we are able to send out our hub link later this afternoon, along with the webinar recording that I mentioned earlier. And then you are able to see if you can get your questions answered that way. But today's a great opportunity for you to ask Rob yourself directly. I know, let me check the chat. I know we've had a couple of things ping while we were discussing stuff. Let me read. I know Jim had a question, but I think Kara had passed the question along to the patents team, so I'm sure we'll be able to look at that on the back end and get back to you, Jim. Does anybody else have any questions for Rob before we end today's webinar?
Well, but, if we don't have another question, I just want to launch into one final point about patents, and which is very interesting to me. The operational use of a patent is, of course, to stop infringers. You go to court, you stop infringers, but typically that's not the only value people get from the patent property. As I mentioned, it's a property right, so you could get value from it just hanging it on your wall as a source of pride. Most people wouldn't invest the funds required just for that purpose. But aside from that, you can use a patent, number one, to show your sophistication to potential investors. Number two, to secure financing for your company as a piece of collateral. Number three, to oftentimes I hear from my clients, it helps them sell products if they can put patent pending or a patent number on their consumer product, even though it shouldn't. I mean, it's not actually a government seal of approval, but the patent pending marker is often accepted by consumers as some kind of indication of quality, whether they should or shouldn't. But people do like to put patent pending, or they like to put the patent number on their consumer products to help market. So there are lots of reasons to get a patent. And I didn't even mention licensing. As a patent property is, in one respect, it's a piece of paper you hold in your hand or an electronic file on your computer. But it's a licensable right. So you can go to the market and do what we call technology transfer. If you're not the person who's best positioned in the marketplace to build a widget because you don't have the good factory that someone else has, it could be efficient in the marketplace for you to license your new idea to the company with the best factory for building widgets. And then, you can share in the profits you make from putting something out on the market that didn't exist before.
Those are all great points. Allison asked, do patents expire?
They do, in fact. They can expire one of two ways. Number one is, in the United States, there are 3 moments in time where the United States government wants to receive what they call a maintenance fee. They're at the 3.5 year after issuance point, then the 7.5 year, then the 11.5 year. And these are increasing. Sometimes they're called annuities, but we call them maintenance fees in the US. So you have to pay your maintenance fee, and if you don't, the penalty, there's no penalty exactly, but if you don't pay the maintenance fee at the 3.5, 7.5, 11.5 year point, your patent will expire. If it hasn't expired for that, if you've paid your maintenance fees, then patent term is its own complicated. We could have an hour-long discussion of that, but the basic rule is that patents in the U.S. will expire 20 years after the earliest effective filing date.
Okay, and then if they do expire for those 20 years, is it just fair game for that, or how does that work?
It is, and that's fine. I mean, that's the constitutional and statutory scheme. So if there's, in fact, there are folks out there who make it a business of, let's say, patrolling patent expirations. And if they see something that's a good, successful consumer product just coming off patent, then there's no law that says you have to stay away from that. You can practice you can be an otherwise infringer doing exactly what the inventor wrote about if you start doing it only the day the patent expires.
Wow, I
Or to
had
be
no
clear,
idea.
maybe the day after the patent expires,
Yeah,
just to add a
play it safe.
yeah. And that's really part of the whole purpose of the patent system is you're advancing technology by giving people a reward for their innovations, but you only give that reward for a limited time. That's what it says in Article 1, Section 1, Clause 8 of the Constitution. Or is it Article 1? I should get this right. Article 1, Section 8, Clause 8.
There you go.
Yeah.
And so that just kind of what avoids monopolies at that point.
Right. So that's right.
That's awesome. I had no idea. I feel like I've learned so much from just this conversation, asking basic questions, and I hope our audience members also learned just as much as I did, if not more. As I mentioned, Rob will be available for questions right now. If not, we will send his information out along with the link to our awesome hub where you can get free resources. The webinar will be there as well, and you are able to send us a message if you are interested in getting something patented and want to start that process with us.
Well,
Um,
yeah. Well, thank you so much for letting me talk about my favorite topic. I've really had a great time, and
yes,
I hope I've been able to educate people a little bit.
absolutely. Thank you so much for being with us today, Rob. It's really been fun chatting with you for the past hour or so.
You're
So that will
welcome.
conclude today's webinar. Thank you everyone for joining us, and we will see you soon.